Hello, I'm Circuit Judge Lee Hayworth, assigned to the Juvenile Court in Sarasota. Together with my colleague Scott Brownell in Manatee County, we preside over every juvenile delinquency case filed in these two counties. If you're the parent or guardian of a child who's already in juvenile court, or if you are the parent or guardian of a child who's acting in such a way that might bring them in front of a judge, this presentation is for you. We think this discussion will be useful for the kids themselves to see, as there are many urban myths circulating about how youngsters are treated in juvenile court. We may dispel some of these myths. With my panel of attorneys and experts here, we will discuss some of the serious issues judges, lawyers, and kids confront every day in court. And we will explain some of the harsh realities of juvenile justice, because our goal is to get the word out to the young people and their families that there are consequences for delinquent behavior, and that their lives can be forever changed in a very unhappy way for thoughtless and risky behavior. Now, let me introduce our panel. We have here Nicole Jones, who's received her bachelor's degree in 2007 from George Mason University in Virginia, where she graduated cum laude. She's a Stetson Law School graduate, now serving as an assistant state attorney in Ed Brodsky, our elected state attorney's office, since 2011. She's been a prosecutor in the juvenile division since 2012. Welcome, Nicole.
Thank you.
Next to her is Rebecca Wilson. Ms. Wilson is an assistant public defender, an undergraduate degree from the University of Wisconsin-Madison in 1987. She is a graduate of the William Mitchell College of Law in St. Paul, Minnesota. She got her JD in 1990, and she's worked in our juvenile division since 1999. She is now the public defender supervisor in that division, and I have to say she's a recent recipient of the circuit's prestigious Jim Slater Award, which recognizes outstanding professionalism in the area of criminal defense. Next to her is Dr. Brad S. Broder. Dr. Broder received his undergraduate degree from State University of New York, received his master's in rehabilitative psychology from NYU, and a PhD in clinical psychology at Hofstra University. He also did postdoctoral studies at the Albert Ellis Institute for Rational Emotive Therapy in New York City, which is quite an honor. He has an active practice in Sarasota with adults and children, including substance abuse and sexual offender and victim counseling. Now, the legislature sets the rules for how we treat juveniles. So the first thing we're going to do is talk about how the goals of juvenile court differ from those of the adult court. And to do that, I'll start with Ms. Jones. Ms. Jones, what would you tell me about how things are different from the legislative perspective?
They're different because in juvenile court, we gear our court system for rehabilitative needs of the juvenile, best interests of the child, where in the adult system, it's more of a punitive function where an adult offender is punished for the crime that he had committed. Where juveniles, we try to rehabilitate them so they do not become lifelong offenders. So
in other words, we're giving them more chances than we would give an adult.
Yes.
And Ms. Wilson, you've had considerable experience in this area. How do you feel about that approach to juveniles? Do you think that's a worthwhile goal?
I do think it's a worthwhile goal because they are juveniles. Their brains aren't fully developed, which I'm sure Dr. Broder will get into. And it's worth trying to get them to change their behavior before they end up with serious criminal charges or in the adult system. And I think at the age when they're in juvenile court, there's a better chance to get them to actually realize their mistakes and change their behavior.
I think it would be helpful to get things in context, to talk about basically the three consequences or processes that we have in juvenile court. The first is pretrial intervention, which is a process by which children are diverted into process to try to get them redirected without having them come through the criminal justice or the juvenile justice system. The ones that fail that or don't qualify will go into, if they're found guilty or they plead guilty to delinquent acts, will receive probation. And we'll talk about that a little bit more later as to the conditions and sanctions that we impose for juvenile offenders. And the third is commitment programs, where a child who has failed in the community, we've given them several opportunities to show they're trustworthy and not violating the law, will be selected for treatment in a lockdown residential facility somewhere in the state of Florida. But those are the three general ways we treat juveniles, but there are important exceptions. And one of these is what we call direct filing by the state attorney, because in certain situations, they are treated as adults. So I'm going to talk to you, Ms. Jones, first. Tell me, what is direct file, and how does the state attorney determine which children qualify for that?
A direct file is a process where, as you said, Judge Hayworth, the state feels that the crime, in accordance with the child's prior history, if there is any, warrants that he be tried as an adult and should not be in the juvenile justice system. There is a statute that mandates what is discretionary direct files and mandatory direct files. So our office looks at basically the statute for compliance between 14 and 15-year-old children for direct files. The mandatory direct file for that would be if they've previously been direct filed and have been found to have been adjudicated as an adult, then every case thereafter would automatically be direct filed. The other mandatory sanction for a 14 or 15-year-old mandatory direct file would be if the crime was a grand theft auto or a carjacking, and during that commission of that crime, they kill or cause great bodily harm to another individual.
Well, when we talk about direct filing, we're talking about the way the case is started. In a delinquency setting, the way the litigation is started against the child is by a petition for delinquency filed by the state attorney. But in an adult setting, when they're selected for direct filing, what you're saying is you're filing directly against them a criminal information, which is the charging document by which a person is informed of what crimes they are alleged to have committed, right?
Correct.
So let's talk about some of these cases that would qualify for a direct file. Now let's talk a moment about the 10-20 life situation in regards to firearms and deadly weapons used by kids. Under the 10-20 life law, and I'll ask Ms. Wilson, what actually is 10-20 life in the adult context, and we'll talk about it as it relates to juveniles.
Well, in the simplest terms, you get 10 years if you possess a firearm. You get 20 years if you discharge the firearm, and you can get up to life if there's serious bodily injury or death.
One of the interesting things about the law is that the 10-year sentence, and again, these are sentences in the adult court. The judge has no discretion about lowering. It's got to be at least those sentences. And it's not just committing or attempting to commit certain types of felonies. It is attempting. You don't have to actually commit the crime. You can attempt to commit it, right? And there's a whole list of crimes that apply to that. And I've got a list of them here. Some of them you would expect, like sexual battery, murder, and that sort of thing. But it also relates to crimes such as aggravated stalking and, possession of a firearm by a convicted felon, aggravated battery. Those sort of things can give rise to it. Aggravated child abuse can give rise to that. So those are types of crimes that you can file, the state attorney can file directly on. And there's been some developments with the U.S. Supreme Court in that area. Ms. Jones, would you like to comment on one of those?
Sure. The case is Graham v. Florida, and that basically states that if the child is direct filed and is convicted of a non-homicidal offense, they are not able to get life. The case actually states that they can get life, but it has to be life with parole. And in Florida, we do not offer parole. Therefore, if they were to commit the crime in Florida, they would not be eligible for a life sentence.
And so one of the issues the legislature is wrestling with, and has for, I think, 2 years or so, is how to treat juveniles who qualify for the 10-20 life, and how should they be given a sentence. And Ms. Wilson, do you have any position on what should happen there?
Well, I think that they need to take into consideration the age of the child at the time of the crime. They have to look into their background, the family, how they were raised in their family, what went on in their family, and they need to make a decision how many years they should get. I don't believe in life in prison for juveniles. I agree with the United States Supreme Court that basically, I believe in the Graham case, they talked about you could have a 5-year-old child who could be sentenced to life at that time, life without possibility of parole. Well, that child's going to do substantially more time than an adult ever would. And they even compared, I believe, a 16 or 17-year-old with somebody who was 65 or 75-year-old with the same charge. Obviously, the child is going to do substantially more years.
Well, in case there's some folks, kids viewing this that think, well, that's great, I don't get life if I commit murder or one of these serious crimes. I think they need to understand that the amount of time they'll be given, it may seem like life to them because it may be 30, 40, 50 years. We don't know until that sorts out, but it's going to be a lot of time, and no child wants to expose themselves to that much imprisonment. So we're trying to get the word out to folks in the community that, especially when it comes to using firearms. And Ms. Jones, do you remember any particular incidents that you get an example of a child using a firearm that resulted in direct file?
Yes, there was actually just a recent case. There were 4 juvenile offenders that robbed 3 adult victims. It was basically a setup sting operation. The victims had gone over to their house to buy oxycodone pills. The juveniles had set up the sting. There was never any oxycodone to buy. Once they went into the house, they held up the victims at gunpoint and robbed them for $300. 3 of the 4 juveniles were direct filed.
And so looking at what kind of sentence then?
The one juvenile that actually possessed the gun would fall under the 1020 life statute because that is a requirement for the 1020 life statute, is that the person actually possess the firearm. So he is facing a minimum of 10 years because he possessed it during the commission of a felony. The other 2 would fall somewhere in between, possibly the same sanction, but it's not a mandatory minimum that they would receive.
And what needs to be emphasized here, we're talking minimums. Judges can look at what happened and actually impose more than the minimum, and it depends a lot what's going on with that child and how the judge feels about the seriousness of it. One of the things we like to do in this program is to point out some of the quirks in the law that, that can get people serious consequences. And one of the examples I want to give is on an armed burglary of a home. Now, the way the statute is written, Ms. Wilson, does it make any difference? Let's say a kid breaks into a house, he doesn't have any weapon or firearm with him, but he finds one in there, and he says, boy, that's great, I'm going to take this 9mm Glock, and I'm going to take it out, and I'm going to steal it after he's burglarized the home. How would that be treated in court?
The child would still be charged with an armed burglary, and it would be the same. Instead of a Glock, let's say they took a knife. Like a large kitchen knife, which could be deemed a weapon. If you arm yourself when you're in the property, whether you're stealing a gun or whatever other weapon you can find, the state attorney has a right to charge you with armed burglary. Okay,
and that's a serious penalty, and that's one that could trigger very easily a direct file for a child.
It could trigger a direct file, and if for some reason the state did not, even as a juvenile, if you aren't committed to a program, you are required to do secure detention time, and your pretrial detention period does not count towards that.
Okay. Well, another area where we're finding that children can be stigmatized for a considerable period of time, their entire lives, concerns sexual battery cases and what we call lewd and lascivious behavior or conduct on a child. And let's talk about that for just a moment. What we call child-on-child sex activity. Ms. Jones, does it make any difference if the child who's been the victim gave consent?
No. Lewd and lascivious molestation or battery is a strict liability crime. That means if the victim had given consent, if the victim had lied about their age, if the defendant believed their age to be older, that is not a defense to the crime. Therefore, they would be charged, and consent nor age would be a defense that they could raise.
Ms. Wilson, what concerns do you have as a public defender when you're representing somebody charged with that? How can those type of charges follow somebody into their adult life?
Well, with the change in the law, juveniles are now required to register as sex offenders. So in certain situations, a child who is found guilty or pleased to a charge of either lewd and lascivious or sexual battery may have to register as a sex offender for at least 25 years. At 25 years, they're entitled to request or petition the court and the state attorney to take them off the list. But once you have to register I guess as a public defender, my assumption is you will not be allowed to be taken off the list. And there's strict requirements. And if, for example, you set up an email account and you forget to tell the sheriff's department that you have an email account, that becomes a third-degree felony. So every time you violate in each individual thing, so if you get a cell phone and you forget to give the cell phone number, that's a separate charge and it's a third-degree felony. So that's a concern for me, especially when we're dealing with children who aren't always thinking of consequences. And for a child to set up an email account and forget to tell the sheriff's department, I think is probably a pretty good thing that's going to happen, and yet the child's going to end up facing another felony.
So a specific example would be a 16-year-old boy having sexual relation with a 14-year-old girl? Yes. That could lead to a lewd and lascivious act of crime?
Yes.
And that could be with them the rest of their life, or 25 years anyway?
Correct.
All right. So how do you try to address that to keep that stigma from happening when you have what appears to be perhaps an isolated incident? What treatment alternatives are there for children in that position?
We often have the children go through a psychosexual evaluation, and if they're deemed to be amenable to outpatient treatment, we do send them to outpatient treatment. We call that, it used to be called a Walker Plan. Technically, it's called a treatment plan now. It can be up to 2 years. They're in outpatient sex offender counseling. There's very strict requirements with that. What you can watch, obviously you can't watch R-rated movies, no contact with anyone younger than you or the alleged victim. And we try and resolve them that way. If the child can successfully complete that, then normally the charges are dismissed.
Before we leave the subject of registering as a sex offender, let's talk just a little bit about what that means. Can they change locations without notifying law enforcement?
No.
They have to tell the sheriff every time they move. So if they go to college, for example, they're going to have to do that. And there's all sorts of bad things that can happen. Well, for one thing, it could be all over the internet that a person's been accused of this. It used to be that everything happened in juvenile court was sealed, confidential, nobody knew about it. But the legislature's moved away from that. Whether we like it or not, that's the way the legislature has gone. And so this is one area where kids really need to know the serious consequences of that type of behavior. So I want to ask Dr. Broder, you treat folks that have been victims of sexual abuse, children, and also perpetrators. How do you feel about the prospects of treating those individuals?
Well, a lot of times it depends on the context of the situation. If we go back to the example you raised about the 16-year-old boy and with the 14-year-old, and that's his first girlfriend, and they were romantically involved, and it was a one-time incident, then the prognosis for the treatment in that kind of situation is much more favorable than a guarded situation whereby someone, a similar 16-year-old boy had repeatedly gone through a number of different quote-unquote love relationships with different girls, and he had learned this behavior perhaps through having been abused himself, and now has become in a sense, habituated to that activity as a way of dealing with his feelings. So in that situation, the prognosis would be much more guarded. So getting back to what my colleague said here about the psychosexual assessment, that would absolutely be required before we started treatment so we could understand the full contextual cues related to the offense.
And one of the things that's very challenging for children that working through this, they can't have internet access. Right. Unless it's restricted, right? Even then, it has to be very carefully monitored. They can do their homework, but they can't be on surfing or doing Facebook or Instagram or any of those things. Those are forbidden. And if they violate it, under this treatment plan you're talking about, they violate the treatment plan, they come back in, they get adjudicated for this sexual offense, and they're stigmatized the rest of their life. So that's one of the problems that we see and that children need to know about. Hopefully we'll think about that before they engage in that activity.
Well, Your Honor, may I interject there? Because this is going to become a much more widespread problem, I have to predict, unfortunately, because when we have certain quote-unquote celebrities like a Miley Cyrus doing her gyrations, etc., we're going to have the teens think that having sex is A-okay. That, again, that example of the 16 and the 14-year-old, they're not viewing that as problematic behavior. They're viewing that this is what we're entitled to, and you know, with the maturation process taking hold earlier in one's life development, I think we have to try to work with the communities and the school system to get the words out about some of these ramifications.
The other thing that I want to get into now is some of the things that kids might consider trivial, but that can become very serious. Let's talk about sexting. First off, who can define it? Who wants to define it for me? Ms. Jones, I'll let you take a shot at it.
Sexting is basically any form of transmission of nudity, be it via text message, internet, Facebook, Twitter, either sending the text or receiving it.
Really? So if somebody just gets us a text from a friend in school and it's a nude thing, they also can be charged with sexting?
They could. If someone were to receive a text message that they did not solicit, they would have to immediately report it to either their parent, a school official, or law enforcement official, in addition to not distributing out to a third party.
Okay, so the person gets this and they say, I want to show this to my buddy. They're committing the offense too. And you're saying they're also committing the offense if they receive this and don't report it to some adult.
Correct.
Wow, that's pretty serious.
It's pretty intense, especially for children, because if they received an unsolicited photo, it might not cross their mind that they have to report it. You know, they might keep it on their phone without deleting it, or not think about deleting it or reporting it, and then they could be charged just as well as the person who sent it to them.
And this is one of those crimes that is graduated, that can get more serious the more times it happens. Ms. Wilson, how does that work? Say the first offense for a sexting offense.
The first offense, you receive a citation, and I believe the most hours you can get is 8 hours of community service or a fine. They normally appear in front of your honor, and they have to report back with their hours. The second time, it becomes a first-degree misdemeanor, and then the third time it becomes a third-degree felony. So it does get more serious, and I agree with Dr. Broder that I think this is something our society really needs to get out to kids, because they don't understand that. You watch what happens on TV with Miley Cyrus and all the other celebrities, and to the kids, this is normal behavior because that's what they're seeing on TV. And they don't realize that, and I know we've created a form that we actually have them sign explaining the different consequences so that hopefully in the future they won't get in trouble again.
So sexting is one of those crimes that children would not recognize as being serious, perhaps, when they're doing it. Mm-hmm. How about somebody who threatens to kill or injure another person on, say, a Facebook page or a Twitter, saying, I'm going to hurt this person? Does that constitute a crime, Ms. Jones?
It does. If the threat is written, it used to be that someone would actually have to take the time to send someone a letter or mail it to them. But nowadays with social media, it's easy to access or just immediately write down your thoughts without thinking. And therefore it falls under the written threats, which is a felony. The problem with Facebook is if their page is public, they're basically announcing it to the world. So even though they would like to have the defense that, oh, they weren't my friend, I didn't mean to send it to them, if their Facebook page or Twitter page is public, initially they are sending it directly to that person. If their page is marked private, they would have to be their friend. But the other part of that statute is if you write down a threat and send it to someone's family member. So this can cause a problem where if they think, oh, I don't have an issue, I'm marked private on Facebook, only my friends will see it, they don't know whose family member they may be friends with. So if one of their friends happens to be that person's family member, they are committing the crime.
Thanks. That's good to know that. Let's talk about petty theft, shoplifting. Under the law, they call it petty theft as opposed to grand theft. What's the difference between a petty theft and grand theft, Ms. Wilson?
It would be the value. So we have a second-degree misdemeanor petty theft, which is under $100. A first-degree misdemeanor would be $100 to $300, and then a third-degree felony would be $300 or more.
Well, kids that are out shoplifting, sometimes they think, well, I can do this as much as I want. It's just a little misdemeanor sort of thing. Isn't this one of our graduated crimes, too, that can result in more serious activity?
Yes.
What is that, Ms. Wilson? How does that work?
This is how I normally describe it to kids when they're being arraigned. If you have your petty theft, and if you are adjudicated on this charge, and then you steal my pen, how much is my pen worth? Maybe 50 cents, $1. It becomes a first-degree misdemeanor. If you steal my pen a third time, it becomes a third-degree felony. So you're looking at second-degree misdemeanor, 60 days in a program, first-degree misdemeanor, a year in a program, third-degree felony, up to 5 years in a program, all for a pen.
And that's kind of the same approach they take on what we call a simple battery, isn't it?
Yes.
In other words, a kid gets in fights 3 times, and there's nobody seriously injured. The schoolyard, what we used to call a schoolyard fight, that can also mature into a felony. Is that right?
That is correct.
Okay. Let's talk about school board employees. We seem to see children acting out against school board employees, which basically is a teacher. It could be a SRO. It could be any of these folks that work on the school property. Ms. Jones, how is that treated by the law?
Batteries on a school board employee are actually third-degree felonies. They're enhanced because they have a function of a public official or someone like law enforcement. Therefore, they're treated harsher than if a child would batter another child.
Okay. Another case that we see frequently in court is domestic violence by a child against a parent. Ms. Wilson, what are your concerns when you see that?
Well, part of my concern is what's going on in the house, that the child feels that they can go after their parent, and what part did the parent play in that? Because as we all know, parents know how to push their children's buttons, and the children also know how to push their parents' buttons. And as the defense attorney, you also have to look at the safety of both the alleged victim and the child if they go back to the home. If they can't go back to the home, then we try and find respite care at the shelters, and if that doesn't work as a last resort, the child has to stay in detention, which can be fairly traumatic for a trial.
And can't they stay several days in detention? And that's a place in Manatee County. We don't have any facilities in Sarasota County for children to be detained, do we?
No. The detention centers in Manatee County, and normally we set reviews every 48 hours if the child stays in detention.
But I think the point you made about going in and looking at the context, the family constitution, because I know I have had a lot of situations where teenage boys are actually trying to defend their mother who's being abused by the father, and then they intervene, and then they might be the one who's kind of carted off. So again, I think we have to look at the whole family interaction and what that system is perhaps evoking in the teenager.
Yeah, those family dynamics are very hard to get into in a brief amount of time that we have when they come in for their detention hearing, which is what we do every day in court for children who may be sent off to our juvenile detention center. But it could be up to 3 to 5 days for the child if they batter their parent and the court finds that the child needs to be away from the parents and they won't go. We do have a youth shelter.
Right.
Yes.
Right?
Right.
And so that's always an option, but sometimes the youth shelters are either full or they won't take the kids if it's really a violent act.
Right.
So the kids wind up basically behind bars up here in Manatee County. All right. One of the interesting things too, developing in the law, when I referred before to the fact that juvenile records used to be sealed, nobody knew what was going on. What happens if a kid gets arrested and taken to the sheriff's department? Now he's under 18. We're talking about kids. We're talking about any child that's under the age of 18. And he's booked and he got a mug shot and it's a felony. Ms. Wilson, what's the consequence of that?
The photo will appear on the sheriff's website. I've had clients who have been arrested on felonies and their names appear in the newspaper, and that is legal. The sheriff's department has a right to release those names since they're felony charges.
So the crimes that we've talked about that we said appear to be trivial, that can have serious consequences, the sexting when it reaches the felony level, the threat to kill or injure on a Facebook or Twitter page, the third time petty theft, batteries, simple batteries 3 times, or battery on a school board employee, those things can result in a mugshot. And the thing about it is now that those things go out into the stratosphere and the cloud and they're there forever. When a guy or woman, a girl tries to apply for a job, wants to get go in the military, perhaps wants to just date somebody and they Google this person, and up pops the mugshot. It has profound consequences for kids, and we're trying to convince them, it's not like it was in 1955 or so when I was growing up here in Sarasota. You've got to be very careful because your conduct is going to be in the permanent record of the cloud, and your kids, your grandkids, and everybody in the world is going to be able to see it. And that's a very disappointing thing for kids, so they need to know about that. I want to move now into the area of drug use and share with you a statistic that we have based upon our drug court and our supervised pretrial release program. We have a policy of testing every child who comes in that's held in secure detention or home detention, which we'll explain in a few minutes, for drugs. And we're hitting a 55% positive rate, which means that more than half of the kids coming in that we put in secure detention or home detention are testing positive for marijuana. And the word on the street is that it's harmless. Can't hurt kids, better than beer or alcohol. And I know, Dr. Broder, you have done work in this area. What's your take on the kids' belief that this is a harmless product or drug?
Well, once again, it's kind of glorified through some of the films and TV shows, and everyone, you know, they can have a joint or, you know, share a blunt or what have you. But more than that, they view it as it's not as bad as alcohol. And after all, I see mom and dad are having a drink, or they have a cocktail with dinner, or we have wine, and everyone's celebrating for the holidays. So, as you put it, the word on the street is that it's okay. It just makes me feel good. What's wrong?
Is there a difference between how the active ingredient in marijuana, the tetrahydrocannabinol, affects adolescents versus an adult?
Certainly is some very interesting research in neuropsychology where they had found, as I think you alluded to earlier, the developing brain for females doesn't mature, or the developmental process doesn't stop until age 22 to 23, and for males it's 24 to 25. So for those kids that are using from, particularly in the cutoff in this research was age 14, so age 14 and younger had a 6 times greater likelihood of becoming addicted to cannabis if they were using, as opposed to the comparison group was people who just started smoking, let's say in college, age 20 and above. So the younger the person starts using, the more likely they will become addicted.
I believe I saw a study out of New Zealand too with about 1,000 subjects indicating that there could be as much as 8 IQ points lost by heavy users of marijuana during their adolescent years. It's something to do with the fact that their brains are developing, and that the active ingredient in marijuana disrupts the normal development of the brain, and therefore when they reach maturity at 25 or 30 years old, they are unable to remember things, their motor skills are not as good, their employers are reporting poor performances. And you know, the literature is not at the point where everybody can say 100% certainty, but certainly any child who's taken a chance with their brain development is really risking some serious consequences later in life. So that's one of the things we'd like to talk about. And let me ask you, Dr. Broder, what red flags should a parent look for in regards to a child who, you know, say they're 13 or 14 years old and they start acting a little differently? What should the parents look for?
Well, I try to talk to parents, particularly about parents and sometimes teachers also, when I'm doing my work, is to have them focus on 3 major categories: behavior, mood or affect, and physical signs. And when they look at those changes, for example, a behavioral change would be the kid liked to play Little League baseball and suddenly loses interest in his or her preferred sport or activity. More withdrawal. Physical signs would be the red, bloodshot eyes, the sleep disturbance, appetite disturbance. A mood or affective disturbance would be suddenly just very silly, giddy behavior out of the blue. I had one parent describe the situation where the kid would normally politely listen to the family dinner conversation, but then one night came in and was leading the conversation and talking it through, and it was just a complete contrast to what the quote-unquote normal behavior was. So if we look in those 3 categories, behavior, mood, and physical signs, you can usually pick up. No one knows their child better than the parents, and they have to trust their instincts.
I think parents need to know too, if they have a suspicion that one of their children is using, they can take the child down to the drug court in Sarasota, which is right next to Hollywood 20 on Main Street, and get them tested relatively inexpensively. And I would encourage them to do that if they're concerned about their children's behavior. But it's not just marijuana or alcohol. There are these new drugs out that are called K2 is one, and Spice, and there's a bunch of street names for a variety of them. Ms. Wilson, have you had any experience with children who have been using those as clients of yours?
Yes, we are seeing probably an uprise in juveniles that are using K2, and maybe Dr. Broder can explain this. According to the families, it seems to make them more violent, the use of the Spice or the K2.
Have you had experience with that too, Doctor?
Well, yeah, and they're what addicted, and what they're finding is that this has really nothing to do with marijuana. It's not THC. It's some sort of insecticide or poison chemicals are being sprayed on these leaf-looking things that, you know, is obviously having very detrimental effects on the brain and making the child, the teenager, much more agitated and easier provoked, and then lashing out in response to that.
And I think the physical effects of some of these so-called artificial marijuana substances have been pretty profound. We've had, I can recall a child that came in admitting to use K2, was coughing up blood, and the parents were extremely concerned about it because it can be available commercially out on the street in certain convenience stores and other places, even on the internet. Apparently it can be purchased. And what's happening is the legislature will outlaw one form of this artificial drug, and then the contents will be slightly modified, and then they'll have to modify the law again. But the bottom line is it's tearing up the insides of these kids and messing them up in the head, and most of these kids need all the brain cells that they can get. So all right, let's take a few minutes and explain the process by which a child comes into the juvenile justice system. Let's talk about a child who's arrested, say, today. Let's say it's a crime, perhaps it's a battery, say a battery on a school board employee. Let's talk first about pretrial intervention. What is that, Ms. Jones?
Pretrial intervention is a diversionary program. So anyone that's basically a first-time offender for either misdemeanor charges, except for something like exposure of sexual organs or a weapons charge, would usually qualify for a pretrial intervention program, and that's what PTI stands for. Additionally, certain felonies as well. And basically what that is they're given sanctions, community service, apology letters, possibly some counseling, drug rehabilitation if needed. If they successfully complete those sanctions in the time frame they're allotted, then the charge ultimately gets dropped.
Who decides whether to offer pretrial intervention?
It is the state attorney's office.
So the judge has nothing to say about it, defense lawyer has nothing to say. Basically, it's the state attorney's call.
Correct.
Now, what happens if the youth fails to complete the pretrial intervention? Let's follow it through the whole process. What would happen then?
Certain crimes, the state initially files a petition, and if they are successful with the pretrial intervention program, the case is then administratively dismissed. Other crimes, the petition is never filed, and they're given that opportunity to complete the program. If they complete the program, it is successful. There's not even a petition filed. In either case, if the child fails the PTI program, they don't complete their community service, they don't do a sanction, or they get a new law violation, which would kick them out of the program. Either for the kids that didn't have a petition filed, one would be filed, and for the other ones that did have a petition, it would come back in front of your honor for more severe sanctions. Usually at that point, it would be some type of probationary sanction, which would then include a curfew, more hours, and more sanctions.
Well, let's say a child's picked up and it's a serious charge, and where are they taken physically? What is the location, what do we call the facility where they're taken to be screened?
It's the Juvenile Assessment Center.
All right, and each county has their own, typically it's in the jail, someplace close to the holding facilities, separated from the adults.
Correct.
And when they're there, what happens to them, Ms. Wilson?
They meet with pretrial services. They're, what's called a detention risk assessment instrument, which we call a DRAI, is filled out with your example of a battery on a school board employee. That would be considered a violent third-degree felony. They would get 9 points for that. Their history, their criminal history is also run, and they have to look at that, which is something juveniles seem to forget, that we do keep track of their criminal history. And if they are sent in the adult system, their juvenile record does follow them in the adult system and is used against them. It remains in the system, so we see it. If the child scores, if that's the only offense, the child would more than likely be released in front of your honor on home detention. If the child scores 12 or more points, they would be put in the detention center in Manatee County and come before your honor the very next day.
Let's talk just a moment about the risk assessment instrument. This is a document the legislature has mandated, and you're basically adding up points, right?
Yes.
And based on prior behavior and also the particular crimes with which they're currently charged, right?
That's correct.
They score out to 12 or more points, the court can send them to secure detention. How long do they stay in secure detention?
They can be held in detention initially for up to 21 days. The state attorney, if on certain offenses, has a right to ask for 9 additional days. If it's a direct file case, or if it's a case the state attorney is considering for direct file and our office is already appointed and we're trying to keep the child in the juvenile system, we can agree as the defense to keep the child in longer than that 21-day period and including the 9-day period.
So this is not a situation as an adult, when an adult gets arrested, there's a right to a bond, except in very few circumstances, right? So this is it's not a bond situation. They can't say, well, look, Judge, my family will put up $5,000 for bond and I'll show up. That doesn't work here, does it?
No, it doesn't. It's either they get outright release to the parent, home detention, or secure detention.
And it's not a country club, the juvenile detention center. It's a lockdown facility, and they try to give them education, and they feed them 3 days, 3 times a day, and they have lights out. It's a very stark environment for them. And they try to do it humanely, but it's not a place most children want to go to. So let's talk about home detention. Ms. Jones, tell me what home detention is all about.
Home detention is if you do not score high enough to be held in secure detention, but higher than the points allotted to just be outright released to your parent. And basically on home detention, you are to remain home. The only alternative you have is to go to school, church, or if you get permission from your juvenile probation officer, if you're attending the grocery store or some function with your parent. If you're not with your parent, you are to be in the home. You can't be out in the front yard, you can't check the mail, you are literally, it's kind of like a house arrest situation. Additionally, if we need extra monitoring, we could impose some type of GPS or ankle bracelet.
Okay, so I want to jump back just for a minute to the pretrial interventions. Could you be specific, Ms. Wilson, on the types of programs that a child would be asked to perform or complete as part of the pretrial intervention, which is designed to keep them out of the criminal justice system?
Well, one of the main ones we use is teen court. And in teen court, they go through a mini trial on what the sanction should be. The child has to admit the allegation, and then they would go in front of a jury of their peers, which is other juveniles that are have been in a similar situation, have charges pending. The attorneys involved are actually juveniles who have never been in the juvenile system. Teen Court also does Camp X-Ray, which is a one-day boot camp run by some deputies at the Sheriff's Department. We also have the JDAP program, if Ms. Jones can, juvenile diversion.
Alternative program.
Right. That's a more intensive program. It runs from anywhere from 90 to 120 days. They have a counselor assigned to them. The counselor actually can go to the school, the house. And that one, they work more with the needs of the family, so counseling and stuff like that. We also have the ADAP program that deals with bullying, and I believe that's the adolescent diversion alternative program. They deal with bullying, domestic battery, gang issues, and that's a shorter diversion program than the others. We also do in-house diversion, where we give community service hours and other sanctions.
Let's say the state attorney has looked at the case and decides that this is a case that's not suitable for pretrial intervention, but would be appropriate for a filing of a petition and a trial. When the petition is filed, what's the next event that takes place after you file the petition against the youth?
After the petition is filed, the child gets to appear before Your Honor for what we call an arraignment. And basically at arraignment, it's the time for the child to be read his official charge. because a lot of children are confused that what they're arrested for is not necessarily what they're going to be charged with.
You mean it could change between their arrest and when they're arraigned?
Yes, it can change. Once the state attorney overlooks the case, speaks to law enforcement witnesses, they decide which charge best fits the situation. So it can change. It could increase, be enhanced, or it could drop down, or it could remain the same. So at that point, at arraignment, the juvenile is informed of what charge they're being charged with, and at that time they can enter a plea of either no contest or guilty, or plead not guilty and be set immediately for trial.
So in those cases that we were talking about where you can have graduated charges that start out as a misdemeanor and end up as a felony, I can recall cases where we had a shoplifter come in, accused shoplifter, and thought it was just a misdemeanor, and then you told them that, by the way, you're really facing a felony. It was kind of a big surprise. Again, why we want to get the word out that it's not just a trivial thing. It needs to be addressed seriously. Okay, so you have let's say they plead not guilty. What happens next, Ms. Wilson?
Then, as Ms. Jones stated, it's set for trial. We have a docket sounding a trial. The state attorney and I go through a discovery process where our office receives documentation from the state that they have, that they believe will help them prove their case. In certain cases, serious charges like sex offenses, we do take depositions, and once all the discovery is done, depositions and anything else we decide to do, then we actually go to trial. Juveniles are not entitled to a jury trial. It's a trial in front of Your Honor. So normally they're shorter trials because they're not done in front of the jury, and then Your Honor makes a decision. Okay,
and then let's just assume that one of your few cases, Ms. Wilson, the youth is found guilty. What are the dispositional? In juvenile court, we have a whole bunch of words that mean different things, but we call it after the trial disposition. In adult court, it's called sentencing, but for juvenile court, we call it disposition. What are the dispositional alternatives?
Well, the child can get probation, or they can be put into a commitment program. Ms. Jones ran over some of the probation sanctions. One thing that juveniles need to understand, if it's a possession of marijuana or any kind of drug charge or alcohol or possession of paraphernalia, there is a loss of driver's license, 6 months the first time and 2 years for the subsequent time.
Ms. Jones, why don't you tell us what the typical sanctions are for probation for a juvenile offender?
Typical sanctions are usually 5 to 40 hours of community service. They are not to associate with any youth currently on probation. They're to have no contact with the victim if there is a victim in the case. They have a curfew of 8 o'clock p.m. till 6 a.m. in the morning. Usually it includes an apology letter if there is a victim, counseling services. ADAP we use a lot for children with battery charges or physical violence. It's basically a 10-week program that deals with anger management type situations. Additionally to that, there are costs. There's court costs, there's cost of prosecution, there's investigative costs by the law enforcement agency that initiated the investigation. Additionally, there also may be restitution. So if someone had damaged property or stole something from someone and they did not get it back, they would be responsible for paying the restitution back to the victim.
Now, is it just the child that has to pay the restitution, Ms. Wilson?
No, it's not just the child. The parents are required to help pay the restitution, which a lot of parents don't realize, but as the parent of the child, they're just as responsible. And one other sanction is school. You have to attend school with no unexcused absences, tardies, suspensions, violation of school rules, and that's where a lot of kids end up coming back in front of Your Honor because they violated their probation by getting in trouble at school.
I think the three most common problems for kids on probation are obeying the curfew, and what they need to know is that the law enforcement has their picture and their name, and they bring kids in who are out at 1 o'clock in the morning or at 9 o'clock at night. This is 7 days a week that this rule applies, and what happens to a child that violates Ms. Jones? What would be the sanction for a child that just says, I'm not going to pay attention to the curfew, I'm going to go and do whatever I want?
Usually if it's not a new law violation, the juvenile probation officer will file something we call an order to show cause. It comes before Your Honor, and For the child's first order to show cause, depending on how many alternative sanctions were given to the child, usually a probation officer doesn't file an order to show cause on the first violation. They'll give a child 2 or 3 times of missed curfew with punishments of writing an essay or increased community service hours. When that's not working and the child is still continuing to violate his probation, that is when they'll file an order to show cause. So usually for the first one, the state would be requesting 5 days secure detention, and that's because we know that alternative sanctions have already been tried. Any subsequent violation would then warrant 15 days in secure detention, and that can be stacked.
So the most common ones, I think, are the curfew violation, where they blow it off between 8 and 6 in the morning and they're out doing something they shouldn't, or just being off property. The second one is the drug use, continuing use of marijuana or K2, which we screen for and we do tests for. And then third is truancy at school. Those seem to be the ones that keep recurring here, where kids are getting 5 days here or 15 days in secure detention as a sanction. So the restitution issues can be quite severe, can't they? I mean, we've had people wrecking cars, kids wrecking cars, and it's like $12,000 worth of damage, and the parents are saying, "What? I got to pay this?" So I guess the word to the parents is, you got to watch your kids, because you can wind up paying a lot of money to pay off the restitution. All right, let's talk a minute about the actual programs that are available for kids that are sent to commitment. Ms. Wilson, you've been doing this a long time, and I know you've seen it change over the years, but what do we currently have for a child who's committed to a program for the Department of Juvenile Justice?
Well, I think we still have a minimum risk, which is the Paxton Center in Bradenton. It's a day treatment program, but you go home at night. Then we have low risk programs that are normally anywhere from 60 to 90 days long. And then we go to a moderate risk program, which is, I always tell clients, 6 to 12 months long. I know DJJ says 6 to 9 months, but it depends on how well the child does. And then we go to high risk, which are anywhere from 9 to 18 months, and then maximum risk, which are basically a jail for juveniles, and that can be up to 36 months.
And how long does the juvenile court have jurisdiction over these children?
A child that's committed, the court has jurisdiction while the child's in a program until they're 21, and if the child's released at 21, the court can actually retain jurisdiction until they're 22. If it's probation, it's 19.
All right. I think what kids need to know is that they're not going to be, if they're in one of these commitment programs, they won't be able to go on dates, watch Netflix, do their Twitter, work with their cell phones. Their whole social life comes to a screeching halt, which is a really big shock for a lot of kids who are so used to this technology that we take for granted nowadays. Dr. Broder, how do you treat kids that you see with serious delinquent behaviors?
Well, you really have to involve the family, in my estimation. That's been my experience and my training and background. Kind of piggyback on what you said earlier, Judge, about the parents better be aware and better watch their kids. So we try to stay focused on the family system, and usually there's been a breakdown of communication. There's not enough oversight. There's a lack of involvement and connection. So getting back to the family dinner hour and volunteering and participating with your kids and spending some time and planning activities. So I take a family systems approach and try to really get the parents to be more actively involved, because otherwise a lot of these problems that we're talking about here is just going to escalate into conduct problems, which in adulthood turn into antisocial personality problems, and we have repeat offenders then.
Can you test for kids that you think are going to be sociopaths or they're going to present serious criminal behaviors in the future? Is there something some metric you can use for that?
There are really no specific psychological tests that are going to be able to say, oh, you have this. Psychologists are trained to predict what's going to be in the future, and of course the best predictor is past behavior is the best predictor of future behavior. So if we have these kind of acting out behaviors, we have to intervene on a number of different levels. One of them is on a personal level through counseling and therapy for the child, but a much more important dynamic is on the interrelationships of the family members and involving the community and the school, et cetera.
Okay, thanks. I recently saw some statistics out of the Department of Juvenile Justice, which is indicating good news in the sense that the number of delinquent offenses statewide are down. The bad news is that there seems to be a reduction in services. So I'd like the lawyers here to comment on programs that they have seen us lose that we found valuable, or areas that we don't have any services in. Ms. Jones, I'll start with you.
Specific programs usually involve inpatient and outpatient drug treatment. There aren't any facilities, at least in Sarasota County, where a juvenile can go for inpatient drug treatment. There's a program called Compass, but that is in Port Charlotte. So there's limited resources for a child that does have a drug problem. So I would like to see more.
Ms. Wilson, I know you had some experience with the former program we had here called Independent Living. Describe that program and what happened to it.
Independent living used to be for juveniles that were 16 or 17 years old that couldn't live in their house anymore. It was run by the YMCA. The kids would live there. They would be taught on basically how to pay rent, pay their bills. They would help them get jobs, make sure they continued their education. And due to funding issues, we lost that program several years ago, which a lot of kids could use nowadays.
Well, I see we've run out of time today, but before we leave, I want to review what I call the 10 Commandments of Juvenile Court. These are things that I tell the kids, if you do these things, you won't have to see the judge. And we try to emphasize that there's rules you have to follow in court. And the first one that we do here, that I tell them, is number 1, do not touch drugs. Number 2, do not touch guns. You don't lie to the judge, that's number 3. Number 4, you don't cut school. Number 5, you don't hurt people. Number 6, you don't break things. Number 7, you don't break curfew. Number 8, don't steal things. Number 9, you don't run away. Number 10, don't smoke anything. And then I refer them to number 1, which is don't touch drugs. So I'd like to thank the panel members for their presentation and opinions here today. I appreciate the work that you're doing on it. Ms. Jones, thank you for your help. Ms. Wilson, Dr. Broder. And I want to thank all of our guests for this. Their insight and knowledge has been very helpful about the many facets of juvenile justice. We also want to send a special thanks to METV for making this so possible. We hope to bring you additional programs that will discuss other areas of concern about juvenile justice, including such topics as community involvement, community resources, and services. Thank you for joining us. I'm Judge Lee Hayworth.